Okay, so it's a pleasure and an honor to introduce Hassan Jabareen today. Hassan is one of the preeminent human rights and civil rights lawyers in Israel. He is the Director General of Andala, which is an organization for the defense of the Arab minority, Arab citizens of Israel. And he's also an academic and political theorist. And today he's going to present to us a paper titled, "Can the Court Normalize the Exception on Territoriality Cases of Palestinian Citizens of Israel?" Thanks for being with us, Hassan.
Thank you for inviting me, and I'm also to be within this group because the article is close to the subject of the group, as much as I know about the exception in emergency cases. One of the main projects, as much as I know. One of my lawyers friends from Tel Aviv, we are friends in the personal level, although sometimes we have political disputes. His name is Yaakov Wein. And we had many cases together against that. He represented Haifa University in the cases, and we were against Haifa University about some of the discriminations against Arab students. So we became close, and one day he told me that he represented Arab old man in land cases. And that old man told me, "You are going to lose." And Yaakov was surprised how this old man, he doesn't know Hebrew. In his 75 years old, doesn't know Israeli law, and so sure that Yaakov will lose his case because it's land case. So I asked him, "Why I will lose?" He said, "Land cases we cannot win about." And Yaakov answered him, "But this is state, this is democratic state, this is state for law." And really he got angry. Yeah. He got angry. What there is a racist opinion, stereotypes among the Arabs in Israel against the judiciary system, against Israel law to this degree. But in the end, Yaakov told me, I was surprised at the hearing before the Israeli Supreme Court that he didn't give me to speak. And this time to convince me to withdraw the petition, although I believe that the petition was very, very strong and had a strong argument, and I should win the case. And I was shocked, and in the end, I withdrew in order not to be fed by the expenses of the court. And he told this story because I had also debate at that moment with some of my friends, academic, Jewish, progressive, very progressive academics, that they believe that there is this possibility to bring case before Israeli Supreme Court to have precedent as Mabo decision, the Australian decision on land, which recognized the title of Aboriginal. And I told them, you are going not just to lose, you are going to make damages. And here we are sitting with one of the best lawyers in the country. Let us put your opinion and my opinion, and he is the arbitrator between us. And through this came the story, and my colleagues, my friends didn't listen to our advice, and they went to the Supreme Court, the first district court, and went to the Supreme Court. And although one of the judges was also Palestinian, they lost and they were criticized, I think, unfairly, but they were shot. So my idea about this subject came from that there is something in the land cases of Palestinian Israel, the rule of law doesn't work. And the theoretical question that I asked whether the exception can be in non-emergency cases, and whether the court, the judiciary, can normalize the exception. Normalize the exception meaning to suspend the applicability of constitutional rights without legal authorization or against legal authorization. And until now, the literature which appeared strongly after 9/11, all of them speak about emergency, about the exception as phenomena of emergency, that the exception appears only in emergency cases, and also not examining the cases, but also theoretically cannot appear back in those time, because in those time the court come late, so late, and the executive must act fast. But the question whether the exception can appear in non-emergency cases based on political identity of the entity itself, and whether the court can normalize the exception doesn't appear as a question. In fact, the literature deny this possibility. As the court has that power to work against the legislature. So my article challenged these themes and argued that the exception appear in non-emergency cases, and the court has the ability to suspend constitutional protection. My test case is land cases that appear before the court after the constitutional revolution, after the basic law. Because I have to show that the applicability of constitutional rights could be suspended despite the fact that there is sort of a written constitution. And the case that I started is Qa'dan. Qa'dan gave different promise. In Qa'dan case, when I wrote this article, I read it differently than I read it when in 2001, when I wrote article criticizing the decision, because many of the Israeli legal academics praised it, and I saw that from different angles than they mentioned. And then I wrote an article which appeared in Shpat Mishal, but here I read it differently, that the state in Qa'dan case arguing that we cannot accept Arab person to live in Jewish settlement because we have been colonizing the Arab citizens since the establishment of Israel. Since the establishment of Israel, we were in a project of confiscating their lands and let them live separately than the Jews. And today, this family, Qa'dan family, want to change the project, and they want to challenge the Hitiyashvut project. If we will have the Hitiyashvut project will be Arab Jewish project, it won't be Hitiyashvut project. And if it won't be Hitiyashvut project, there is no Zionism. And if there is no Zionism, there is no Jewish state. So this is something crucial. It's not just Arab family want to live with Jews. And here, Justice Barak said about this case, this is the most difficult case of my career. He didn't say that about the torture case, which is about emergency. He didn't say about many cases that he accepted, that regarding the military action in the occupied territories. I'm not saying that the rights of the Palestinians, their rights were defended by the court, but he saw this case as matter of political identity more difficult than the emergency cases that he did. But as you know, his ruling was that the Jewish and democratic state doesn't prohibit the right of equality for the Arab citizens. The Arab citizens' right for equality is ensured in civil rights. A Jewish state means that in the group rights there is dominant for cultural rights for the Jews in Israel, including the law of return, And in other matters, every citizen should be treated equally. However, about the past is different. My decision is looking forward, not looking backward. The petitioners didn't challenge the past, and no one here going to challenge the past. The past that refers to land confiscation and other cases. Because this refers to the foundation of the state. And indeed, the Qa'dan family, even they accepted the law of return, and they accepted the role of the GNF, the Jewish Agency, as rule that belong to the past and for establishing the state, and they don't challenge their petition looking forward for, and I can put it in real of individual rights are not the human rights. After this decision, we started to view in the legal literature huge material about justifying Jewish and democratic state. In fact, if we examine the legal journals in Israel, before Qa'dan and after Qa'dan, we saw very, very minimum, small number of articles that attempt to justify the notion of Israel as a Jewish and democratic state. I'm not saying that the state wasn't a Jewish state. They're saying about variety. After Qa'dan, we start to see waves, and mostly the Israeli Zionists, liberals, started to write about Jewish and democratic state, and here Qa'dan proved that it was citizens could be equal, and the problem will be in group rights only. But every democratic country has this problem in the group rights also. France, its Frenchness doesn't recognize groups, minority groups, that they have different culture than the dominant French culture. And that time it was really debate between Arab intellectuals and academics and Israel Zionist liberals about this. In this article, I say I want to take that discussion to other angle. I want to examine in individual cases whether Qa'dan promise based on its Zionist perspective to ensure individual rights can work or not, or we still in colonialization function. I refer to the theoretical aspect about the suspension. One of the problems that I faced is how to explain the notion of suspension by the court, because all the legal literature speaking about suspension of the law by the executive, but there is nothing about suspension of the constitutional protection by the court. So my starting point was, in fact, the literature about emergency, the Lockean and Weak model and the new Roman model. The Lockean model say in emergency, the executive branch should be allowed to work against the law without legal authorization, and the only group that can examine after the act the legitimacy of the action of the executive branch is the people, to examine whether it was taken for emergency reasons or not. The new Roman model said, no, we have to put everything in the frame of the law and to ask the legislator, the parliament, the Congress to empower almost freely the executive to act in emergency and to have sort of freedom to take action. So my question is whether in non-emergency cases the court can play the role of the people in the local, but to confer in advance or the role of the new Roman as like the legislator, and to confirm the action and to give reasoning and explanation to the action of the emergency. By this, I try to succeed to explain when we can speak about judicial exception. And I refer to the theory, especially Carl Schmitt, that I found that his theory is very, very relevant to tell us really that the court can suspend the law, because for him there is distinction between the Constitution and constitutional law. The Constitution about the founding political identity of the state, and the constitutional law is the written law, including court judgments and constitutional rights. And all the time, when there is a clash between them, the Constitution trumps the constitutional law. If the Constitution trumps constitutional law, and the sovereign who is suspend the law, the court, as sovereign power, can suspend the law in order to defend the Constitution. And by this, it will gain legitimacy. And the legislator will agree without challenge with the court, and they execute it because the court defends the political identity of the state. So the theories about exception from Schmitt, Foucault, Gandhi, all of them agree that the moment of the exception is the moment that we reach the very essence of the state. Or others would call it the raison d'etat of the state. So I say, or argue, that in fact, if I show the suspension of the law in land cases, we can reach the very essence of the state, and then we come back to Qa'dan and ask whether Justice Barak reached the very essence of the state or not. So the case study refers to two kinds of cases. One kind of cases about returning land which was confiscated in the 50s through emergency regulations. And the second about unrecognized wages. And the cases refer to right of property and also social rights because they are unrecognized wages. And now it's a good opportunity to see that if in the 50s the land were confiscated on the name of emergency regulation or security, so what this notion is doing now when this aspect is not valid anymore, the security threat or the emergency. And after the constitutional revolution based on the basic law, and after some decisions of the court, like Kirasik, the court said if the state confiscated land in the past and didn't use it for the purpose that confiscated the land, should return the land to its owner. So here I talk, in order to show the exception, you have to show the rule that is suspended. The rule in those cases, the right of property as constitutional right, and Kirasik, those laws, whether they will be suspended or not. So one of the leading cases that I discussed is the case of Krith and Dram. And in this case, the state confiscated the two villages in the 48 during the war, and the justification was security reasons based on emergency regulations. And now the people want to return, especially because the state didn't use all the land of the two villages based on Kirasik and based on Qa'dan. Based on Kirasik, because if you didn't use the land that you confiscated, the land should be returned back to its owner. Based on Qa'dan, because Qa'dan say you cannot discriminate Arab in Israel, in civil rights, in individual rights cases. What's important about this case that the court acknowledged that security reasons and the emergency reasons are not valid anymore. There is no security reasons that can justify the prohibition of the people to return. But there is another reason. This is the main reason and the dominant reason. The dominant reason was for the court is the claim of right of return of the Palestinian refugees. Because this could be precedent for the claim of the Palestinian right of return. So in fact, the court gives us ideological reasons which belong to the political identity of the state, how it defines itself as your state, to negate the right of return, and not emergency reasons, meaning the political identity, Trump, the legality here, with no any connection to security reasons. And this case was the first case that the Supreme Court denied a petition based clearly on the claim of the Palestinian for right. In fact, Avigdor Feldman was the lawyer in this case. He asked for second hearing. And you are allowed to ask for second hearing before the Supreme Court when there is a new ruling that doesn't fit the established rulings of the court. And his argument was that for the first time, the court used diplomatic reasons in order to suspend constitutional right. And the court, when they reviewed his request for second hearing, they said, Justice Mazza, you are right. This is the first time that we use diplomatic reasons to suspend constitutional. But this is a unique case. We don't think that it will come again. This is why no need to give you second hearing, because we don't think that this will change the establishment of the ruling. This is really accurate and unique. So we cannot say that we have a new ruling that will change the law. But in fact, after a while, another case similar to Jabareen came, and this time the court said that basic law, human dignity and freedom doesn't apply to this kind of cases. Clear. In unrecognized villages, so I continue to explain some of the cases in this part about land confiscation to show that in the end, the court clearly suspended the ruling of Kerasik and clearly said that the basic law is not applied to such cases. Then, toward the end of this chapter, I asked, does this aspect refer only to historical land confiscation, or can reach other kind of cases? Let us examine the unrecognized cases. Those kind of cases are not about historical land cases. They are, in fact, somehow they are Israeli cases, not Palestinians, in the meaning that all of the phenomena of unrecognized villages was started and established after the establishment of the state. So it's Israeli aspect. Doesn't have Palestinian root going to the foundation of the state or to the history of the foundation. And here I found the same phenomenon. Now at that time, most of the cases that I have for transparency, most of the cases that I mentioned in this, we were the lawyer in the cases. So when we decided to take unrecognized villages, we said, let us distinguish between returning the land or recognizing the village where we won't have chances to win, because the state will see it as it is good cases.
and let us focus on social rights of the people. Right for clinics, both halal, child and mother clinics, building kindergartens for the kids, especially because there are laws that ensure those rights, regardless to the form of the Hitiyashbut, whether you live in a recognized village or unrecognized village. So the first case was about building kindergartens based on the education law in some of the unrecognized villages. And this case came before Justice Barak. And Justice Barak said, it's very difficult for the state to build this kind of kindergarten in unrecognized villages. Because unrecognized villages, illegal villages, and against the urban planning. So we cannot ask the state to do something against the planning law of Israel. However, also we cannot say that the children are not allowed and entitled for kindergarten. And we cannot accept also the argument of the state, which telling us to wait until the dispute between the state and the Bedouin will be solved, then they will have kindergarten. We cannot wait because this dispute has been for decades. So I suggest the balancing theory, the balancing test. I suggest that to provide for them in the future, if they will ask transportation for their kindergarten to other places, and the state will pay for it. This balance, although it's not satisfied, couldn't be satisfied the right, but at least won't fully damage the right for education. The kids will still have right to exercise the right of education. So hereafter, the same villages came and asked transportation. The court denied their petition. Justice Rubinstein gave the case, the decision. With him was Justice Jabareen, the Palestinian justice, and fair justice Ibn Philip. But not Barak. And Justice Rubinstein say, well, there is a problem with the Bedouin. And there is offer of the state, plan for the state to move them to other places. This is national project. We cannot give them this right. And also, we cannot say that they are discriminated against because other we don't supply transportation for kindergarten in the state. It's true because kindergarten are built close to the neighborhood of the children. But Justice Barak, in his decision year before, he almost profited that this argument will be raised. And he said in his decision that, yes, we don't supply transportation for other kids, but equal rights in this case means also to answer the needs. The needs of the Bedouin kids are unique needs. This is why, in the name of equality, to equalize their rights, the state must give this right. But the court of Rubinstein didn't follow Barak. So they deny that case and start the narrative of the Bedouin as living in illegal places, and those illegal places are national threat for the planning of the state, start to be strong on the decisions of the court. That was put in this decision. Justice Barak mentioned that, but try to balance But Justice Rubinstein, in this case, started to put the narrative of the government to give it full legitimacy. After that, the people came with the right of drinking water. And the court said, yes, the right of drinking water is belong to this constitutional right, and we can found it in the right of human dignity. You cannot speak about human dignity without supplying drinking water. And every person is entitled for drinking water, whether he or she are criminals or not. Every human being is entitled. However, the unrecognized villages is different case. We cannot apply fully a constitutional protection on those villages because we want to have negative encouragement to the people in order to leave the villages. We cannot give them water because giving them water will encourage them to remain. So this is very, very important consideration for us. However, we are ready to give and to supply water in very humanitarian cases. So the court referred back the case to the district court in order to examine the humanitarian. The court denied the cases and said, we don't know what's humanitarian here. In those cases, we have no legal standard to apply, and they denied. It was another attempt to connect the unrecognized villages to water, and the court, in all the cases, district court, because this is the court of the water, that should be in mind, deny those cases. So this humanitarian is used, in fact, when legal rights are not applied, because there is no something called the humanitarian right. The humanitarian aspect is entering when you suspend the legality. This is why in the family unification case, the law said that no family unification for the Arabs in Israel with Palestinians living in West Bank and Gaza, except in the humanitarian cases. But the humanitarian cases, based on the law, doesn't include cases that kids have the right, for example, to live with their parents. This is not family unification for humanitarian cases. Until now, we don't know what humanitarian is. So the use of humanitarian, this is the angle when the court doesn't find law to use. This is why the court also decided about the right of people to leave Gaza. The court said in the humanitarian cases. But in fact, the court denied all the cases except Cron's case 3 weeks ago, when about the 2 legs of the Palestinians that to enter. So here, the court in fact suspend legality by using this term. But the case of al-Hiram itself came and suspend totally Qa'dan and the right of God. Because the al-Hiram case is not about being the village unrecognized village. In fact, the village will be recognized and will be built as Hiram. So the aspect of unrecognizing the village by such became marginal. What became now the question is culturally question, whether building Hiram as a Jewish settlement instead of Hiram as Bedouin is legitimate, whether it's legitimate that Bedouin and Jews can live together, or to separate them on the name of multiculturalism. So the court found easy that the Bedouin of Hiram can move to Hor and we can build Hiram. So if Qa'dan came to tell us that Jews and Arabs can live together in villages, or settlement. Here, the case of Hiran, in fact, emphasized the principle that Qa'dan came against it, about separate but unequal. And this is the main thing of Qa'dan, to justify and to tell us what's the main reasoning here. How we can understand to let people who live in their villages for 60 years and with permit of the state, and now to let them move to other places. So here we see that a cultural aspect replaces the security. If in the past security was the main thing, today we are speaking about culture. If security was the main reason to discriminate Arabs, now cultural reason like in Iran, based on multiculturalism, cultural reason could belong also to the political identity of the state, as Jewish state, as it is better, using the right of the claim of the Palestinian right of freedom. So what the court did in all of this, the court clearly suspended the constitutional rights, but the state in all of those cases didn't argue that constitutional rights and the basic law is not applied. They tried to give different interpretation. So why the court took this extreme step when the state itself didn't argue? In Iraq, they didn't say the right of property is not applied. In Ecuador, they didn't say the right of property didn't apply. The court took this measure, in my opinion, in order to apply the local model and the new Roman. Those models based on the fact that in emergency cases, have your emergency measures and don't damage and corrupt the legal order. The legal order of the court is the constitutional revolution. The court doesn't want to give indifferent and weird interpretation for the right of property. The court doesn't want to give weird interpretation to the right of equality. The easiest thing is suspend totally the constitutional protection, and by this you leave the basic law and the case law is clean, the legal order. This is why in the law schools in Israel, when they teach constitutional law, they teach it as a clean. They teach clean law, clean progressive law, because the cases of the suspension of the constitutional rights are not reaching the study of constitutional law. They consider, as Justice Matza said, unique, rare, are not part of the legal order itself. So what the court wanted to achieve succeeded even in the legal academy. This is why also the debate about Piskat Gabrut, the overriding laws, is speaking about giving the authority from a court to defend the rights of minority, national minority, Arabs, and different minority. And in the legal consciousness of most of the law professors in Israel, that the court defend the rights, because they don't reach this aspect. They refer to it as something that doesn't belong to the legal order and doesn't tell us what, and they are not landmark cases. Maybe Milharan will reach. Now, what this will tell us about the Jewish and democratic state? The debate between the Arab intellectuals, academics, and Israeli legal scholars was whether Jewish and democratic state legitimate or not. The Jewish Zionist scholars say it's legitimate because the only suspension is the group rights, not the individual rights. Qa'dan is the group. Those cases has nothing to do with group rights. They are about the group. So the distinction between group rights and individual rights failed in those cases. Second, why the court suspend the legality in those cases? Because the project of fetish food is still project of fetish food as was portrayed by the respondent in Qatar. And they said we must continue colonizing the Arab and we must continue with this project, and those cases goes with their faith. So the colonization, the Arabs inland, still continues by Qatar. Now there is an argument by Sami Samouha that Israel model, the relevant model for Israel is ethnic democracy. Why ethnic democracy? Ethnic, it's true because there is superiority for the Jews in many fields. There are discriminations in most of the fields. But still democracy because main reason. Freedom of expression of the Arabs and their right of participation in the election. They sit in the Knesset. But what those cases tell us, that doesn't matter whether you sit in the Knesset or not, because the legislation is not the main issue. The exception can cure with the mutuality between the executive and the court, regardless of the law. Exactly what's happening in those times. There is no law speak about incubation in Islam. The exception occur in those relationship between the state and between the army, the government, and the court without legislation. Even the validation law, Hukm al-Asdara, there is no need for Hukm al-Asdara in order to confiscate the private lands of the Palestinian based on the case law of Israel Supreme Court. They don't need that. And this is in fact the position of the Attorney General before the court, why he against the validation law Hukm al-Asdara. Said no need for it. So in the end, I challenge the Jewish and Democratic state, I challenge the ethnic democracy, I refer to the ethnocracy of Oren Mustahil as relevant to those cases. However, I say that also he is like Sam Smoha, want to give name to the regime of Israel as a special type, like to call it ethnocracy when colonialism is good model to speak about, and we can, in those cases, look to cases, for example, of the American natives in 19th century and the beginning of 20th century, and we see that it's relevant. As, for example, in Cherokee case of the most important aggressive case against the American Indians or the natives, was that the court recognized the natives and the Indian as separate people, recognized them as a people, and because they are a people, the Congress is allowed to suspend constitutional rights because it's like diplomacy, it's like foreign affair between the American people and another people. So they recognize them in order to exclude them. In al-Hiram, they recognize the Bedouin as Bedouin, and they are separate identity in order to separate them and to put them in home. So my answer to Oren, although like this case study fit his notion that we don't need a new model and we have to start to speak about colonialism. Now, in Israel Law School, this debate, even ethnocracy, didn't reach the law school. In sociology, in political science, they speak about it, but the law school didn't reach that. I am here. Thank you.
Thank you, Hassan, so much. So if people don't mind, I'll start with a little bit of a common question of my own, and then we can open for more conversation around the table. First, I'd like to say that this is part of a larger project that I've been kind of encountering or witnessing from afar in the last few years about the Israeli constitutional law. Very, very important and significant work that fits into a set of papers, and I really, really appreciate that. Now, with that said, I want to raise a few questions about this particular paper. And my comments divide into three parts. One, I think one can call theoretical, second, historical, third, legal. And I think I have questions on each one of these aspects of the paper. First, with regard to the theoretical claims that you make, you work a lot with Schmidt's notion, and as well as the Lockean and Roman kind of developments. I'm not entirely sure that with the materials that you have here, that is the most productive conceptual framework that exists out there. In fact, I think that what you show is much more in line with other authors that have gone much further into the colonial, theorizing the colonial state. That is to say, really, it's not about so much, and this is my reading of the original material, the primary sources that you bring. It's not so much about suspension of anything. It's about the fact that the state, both in the judicial side and on the government side or state side, always, from the beginning to the present, forwarded and advanced a model based on unequal citizenship. And so I'm not saying this is my opinion, but I'm saying this is what I read in the materials that you bring. So we don't need the whole idea of the suspension is just one aspect of something that is really a bigger story and can be identified in the cases that you bring in many ways that really are not so much about the exception. Having said that, there are a number of authors that kind of apply the Schmittian notion, particularly to the colonial context. So first, maybe most importantly, Nasser Hussain, Arjuna Padurai, and so Nasser Hussain really brings the exception to the colonial context. Arjuna Padurai, Fear of Small Numbers, a book from a long time ago about demographics in India, very, I think, useful in this context. And now, more recently, there's a book by John Reynolds about the state of exception in the British context, imperial colonial, and Yael Balda in the Hebrew University also does this kind of conceptual work with the colonial period, which I think fits more to the material that you bring here. Now, with regard to the historical work, so I think that in the beginning, there is a very immediate slippage between Hiteshvut and colonialism, as if that was a translation. And it's not entirely clear, at least, I think it's it makes the reader think that even the court thinks that what it does is colonialism. And I think that's not exactly the case. So I think there's some need for conceptual explanation there.
About
Hiteshvut is settlement, but it's not colonialism.
Yeah, right.
So colonialism is a particular category that maybe is implemented by the Hiteshvut project, but it's not just an immediate movement like that, as it seems to be in the paper. And with regard to the more present history, in your comments when you spoke, you did address these points, but I think they belong also in the paper. So the Kaadan judgment basically was overturned. Yeah. And then we have legislation that solidified that, right? So this needs to be discussed in the paper somehow. I mean, the reader doesn't even know that just encountering the paper, and so the dynamic here is once again a dynamic in which the court and the judiciary are performing a similar role over time. One story, okay. Now, with regard to the legal point, the more legal points, I have just a minor point with regard to Kaadan. I think that to make Barak's decision in Kaadan part of the colonial story, it's not only about Hiteshvut, but it's also about the fact that a Jewish majority is part of the very definition of a Jewish state. This doesn't have to be held as obvious. To give a particular ethnic group the right of majority I think is very much in tension with liberal political theory, because if this particular ethnic group also has particular political interests, and you're saying these political interests will remain the majority no matter what. So it's a very difficult idea in terms of democracy.
Is the impression, just to understand,
Yeah.
the impression of the reader that I accept Qaeda
No. But that you raise most of your
about land.
yes.
Yeah.
And there's also a term, an aspect of representation here that goes in other cases as well, but it's very, very basic and fundamental. And now, with regard to your last comments here, where you say that the court didn't want to somehow diminish the rights, and therefore it creates the exception. And it doesn't want to make the rights weird, as you say, but then it provides these exceptions that the government didn't even ask for. This also is not, I'm not entirely clear that this makes has a lot of explanatory power, because in fact, it had made the category of exception weird. So it's not like it's just kind of creating somehow avoiding the difficulty. It's just creating a different difficulty. So it's not clear to me that
Just if you clarify.
So you say why
like
did
the exception and exception.
No, you say why did the court create exceptions when the government didn't even ask for them? So your answer? Well, the court wanted to protect the cleanliness and the sanctity of rights, so it created an exception. But I don't think that this really solves the problem in any significant way, because it now created a problem with the issues of applicability of law, very, very familiar to people working in international law, with the questions of when does human rights law apply and so forth. And so it created a different set of difficulties. It's not like the court really solved any problem by keeping the rights clean, so to speak, in my mind at least. So those are my thoughts.
Yeah, thank you. It's very, very important. Maybe I will shape also, will help me to shape some of the argument. But first about the theoretical, that there are materials, Nasser Hussain and John and Barda, that they wrote about the exception in colonialism. In fact, this is what I criticize.
Mm-hmm.
Nasser Hussain work is the leading work about the exception in colonialism. He referred his work only to the emergency and security.
Mm-hmm.
John, the same. Yael Barda also, the same. Yael Barda took the West Bank and emergency. And in fact, this work strengthened my argument that even the critique, like Nasser Hussain, that he one of the leading the book, so reading the writer about the exception. In fact, he is the first who say, well, the source of the exception in the colony. And then it came to the state. And the colony in Africa for him and India. But in fact, if we read him, we see that he just state the assumption, that the liberal assumption that exception appear only. Nasser, John, the same. And the Yael Barda, the same. This is why also I try to challenge those aspects. And I mentioned him, I think, in the second, maybe, or the third footnote, about this kind of right. In fact, also I challenge the writing about apartheid. The writing of the apartheid, examining the court of the apartheid, they didn't mention that in fact, David Eisenhower's work about the court during the apartheid, he tried to show that the court can keep the rule of law, can protect the rule of law. Even the work about the apartheid didn't include suspension of the law by the judiciary. In fact, I didn't find any material about suspension of the law by the court in non-emergency cases. There is just a new article that I mentioned it that say that make survey in the world about work of the court and mention some cases that they called it exceptional cases where the court decide on the exception against the legal order in order to bring a new legal order, and Bank Mizrahi one of them. So rare cases like that. Now, this is why I use this framework. Yes, you can say about this article, who needs Schmidt? Go directly to colonialism. Say the state colonized the Arab from the Middle.
Yeah, that's what it reads like.
Okay, yeah, you can't say that.
No.
But if I want to choose theoretical aspect in order to publish it in Icon, I have to do it. Okay. Otherwise, no one will not think we go to Haaretz newspaper. Now, about second, I agree with you, Hitiesh, and it's not giving the explanation about colonialism, colonializing. So maybe I have to explain that this is one angle of that and that. About Qa'dan, you are right that Qa'dan is not about discrimination in land. Also speak about the Jewish supremacy and why I don't speak about it. But this already I spoke about it in other article. I don't want to repeat this. My first article about Qa'dan, when everyone celebrated Qa'dan, I came like Ba'sa, saying, guys, no, I'm against Qa'dan. And Mishpat Mishal, they were angry. They say nice things. And so, and I refer to the, I think I have agree with you. Maybe I don't have to make psychological connection and to ask why the court suspend the law in order to keep the legal order recurring. I just have to lay it as fact. The court suspend the law in Arab cases and left the legal order clean without entering psychology, because maybe there are many reasons more than just to keep the legal order. But as a fact, this is what happened. So better for me not to make the case of sympathy, the contact, and to enter psychology. This is a fact. This is what happened. We can say this, but you are right. Maybe for racist reasons, just say like Ibn al-Haram, who needs Arabs, and didn't think about the legal order. Like, it's true, not in every judge legal consciousness he's worried about the constitution and revolution. So here I have to clarify. Okay, thanks.
I don't know if it's relevant, the French word for settlement is colony.
Huh?
The French term for a settlement is colonie. And the settlers are colonistes.
Yeah, and then the fact the word it is root, it's also settlement, and in the legal literature, the word settlement and colonial settlement, best if we want to translate it to Hebrew, we will use the term mitiyashvut and mitiyashiv and mitiyashiv. In all of the cases, like in the cases that the U.S. Supreme Court delivered in the 19th century and the beginning of 20th century about the natives, they use similar terms that we used in Hebrew. But in Hebrew, it's used as avant-garde, Hanetzi.
Yeah.
You know?
But I following up on that, so I also...
So this will help me. Colony is...
in there are some Hebrew sources, early Hebrew sources, that write Zionist sources, in which it appears that people are writing מה שאנחנו צריכים על מנת לקדם את הקולוניזציה של פלסטינה זה הדברים הבאים. So they speak about colonization, they speak about colonia. Very, in a good way. It's a good thing. We need to do it. you know.
Mm.
So that's also on the continuum. And then my question to you, if we're already talking in this linguistic discussion, I have noticed that in Arabic language, many times the use of the word isti'mar, mustamara, is used also in the Green Line and outside of the
Yeah.
Green Line.
Yeah.
And that's a colony, right?
Yeah.
So,
Yeah. The people of Nazareth use, they don't say Nazaret.
Mm.
Normally they say Ashikun.
No. Mhm.
Ashikun Arabic Mustafa.
Mhm.
They said it above. They don't use that Nazaret. For them, there is just one Nazareth. There is nothing Nazaret. So they call it Shikun. And in Arabic, yeah, they use in many.
But is this term a kind of normatively loaded, or is it just the word?
In the political writing, used Mustamara in the Green Line, whereas the place was built on Arab land, like Nazaret. But you won't see that like to refer to Tel Aviv,
Mm.
to refer to Haifa. In some places, they don't use it. They use Mustawtanat. Mustawtanat in Hebrew, it Yeshvin.
But
So
that
Israel established Hiram.
Yeah.
They use Mustawtan.
But that is also used beyond the Green Line.
Yeah.
I think,
Yeah. In Arabic language, there is no distinction between settlement in the West Bank and settlement in Israel. Rarely you find this. In English, when they speak English, they say settlement in the West Bank.
Right. And also in Hebrew, we don't say hitnachlut inside the West Bank normally.
Yeah. Now the settlers started to emphasize and to speak to the media not to use the term itnahliyot, but
Itashvut.
itashvut.
Mhm.
So this is to normalize.
So if no one, okay.
I'm not a legal person. If we isolate the issue of confiscated land, the precedents where confiscated land was returned to Jews, confiscated from Jews.
I refer to cases about land that was confiscated from Jews. In fact, the validation law of 1953, which is similar to the Hawkas Dara, the new one, also an English validation law. They have the similar notion that you take private land illegally and you take it to the state. Now, some of the land that was confiscated also from Jews. Now, how this land was confiscated from Jews? Because some of the Jewish families, they were partners with Palestinians, and the Palestinians became refugees. So you have few cases of Jewish families, and I refer to them, that also they were victim of the validation law in Hebrew, Hawk Haram. So when they brought it before the court and they said, well, this is our land and this is the validation law is arbitrary law and cannot justify taking our land, and especially our land wasn't used, why not to return it? So Justice Spanish gave reasoning and said, Hawk Haram, this validation law was used during emergency in order to take the land of the people who left like the Palestinian refugees, and it was no law to legalize that taking from them. So we needed this law as emergency law. If this law will pass today, of course, will be illegal. This law by itself, one of the exceptional arbitrary laws that we have in the book, but we cannot return your land that was taken during emergency based on this validation law. So the validation law started to appear through the Jewish cases as exceptional law that the basic law and Kirasic cannot apply. But the first cases that were brought before the court, they were the Jewish families. Like Kirasic is Jewish family. After Kirasic came Jewish families that their land was confiscated through this law because they were partners with the Palestinians. So you have this, but in other field, I don't know, like in the absentee property law of Nasser Kadim, very, very difficult to declare that a Jewish family is absentee because the law of return itself say that Jews cannot be absentee. The law of return say even if a Jewish person is a native Palestinian, was born in Palestine, he will be considered as immigrant. So all the time the Jews are coming. Now, even if they were born here. So the law of return took from them the aspect of being native in order not to make distinction between Jews, Palestinian Jews, and other, and all of them coming. So cannot be absentee because of the law of return. If you read the law of return with the absentee property law. So it's very difficult to use that also against Jews. The question whether you can use it against settlers, because settlers, Israeli citizens, moved to live in the West Bank, and they have property here. And the absentee property law, حكم سنف قديم, say if person has property in Israel and went to the West Bank or Gaza, his property will be absentee. So this law, حكم سنف قديم, wasn't used against settlers, was used against Palestinians who has property in Jerusalem. So the state started to take the property of Palestinians in Jerusalem who live in West Bank. So they said, well, you moved to West Bank, so you live Israel. That means your property become absentee in Jerusalem. We'll take it. So we challenge this policy and we say, if you want to take it to the Palestinian, take it from the settlers. Same rule. Settlers who has property in Jerusalem and live in West Bank, their status should be similar to Palestinians who live in West Bank and have property in Jerusalem. And this was delivered just 3-4 years ago, and the court accepted the idea not to use the absentee property law from now on against Palestinian property in Israel. So the Palestinian got benefits with the comparison with the Jews in this case.
Hassan, can I push you a little bit about the point that you made towards the end, not in this paper, but you still made it here, about the overriding legislation, and about basically the question, does it make a difference to write about Israeli constitutional law from a Palestinian perspective 10 years ago or now? If you compare, part of your writing, as you say, is from 10 or 15 years ago on this topic. And then, you target the Barak court from a critical perspective, but also you embrace some of what the court has done.
Yeah.
I think. And now we are in a different political moment. We are also maybe in a different environment in terms of the judiciary. Does it make a difference in terms of the actual critical perspective that you take in your writing about the court?
There are many versions of the overriding legislation, Scotland government. One of the versions say if the Supreme Court will accept petition against law and decide that this law is unconstitutional, the Knesset will have the authority to override it. Okay? If this version is the version that will be accepted, I don't think that it will make the rights of the Palestinian citizens worse. Why? Because if we compare where the Palestinians can win cases, they can win cases not before the Supreme Court, before lower courts, for the magistrate and the district, which Shalom Mahazim. There, they succeed to win cases more than the Supreme. Why they succeed to win cases more than the Supreme Court? Because those courts don't see themselves as final. And they don't see themselves as putting the they don't judge the high politics of the state. Now, if we will have overriding legislation like the version that I mentioned, the Supreme Court maybe won't see itself as final. And some of the cases they will accept for the Palestinians. Why? Because so far, all the constitutional cases against racist laws, the court accept or confirm all the racist laws. All of them. There is no one racist law that the Supreme Court struck it down. But there are two laws that the Supreme Court was split. The family unification 6 versus 5, Ba'dot Kabbalah 5 versus 4. If you have overriding, maybe the swinging will go easy with against the law. So I will win cases. So the Knesset will override it. But in order to override it, already I have case that decision of Israel Supreme Court that said that this law is racist. And also this will empower the victims. And also this will bring critique, the international critique against the Knesset and say, guys, you are legislating racist laws. This is why I don't see the overriding clause in that version is disaster. Of course, my perspective is very, very utilitarian. Yes, I have to be, because the most of the damage of the rights in colonial state, in colonial regime against the natives. So I have to focus on it. So I don't see it as disaster that way. I am worried about other versions that come and say, well, the Knesset will decide that the human rights law are not applied for 3 years. That's different. But the overriding of decision of the court, I won't be that much concerned if it will be from Al-Tabi perspective.
And
Do you want to have
a question? In the lower side, go ahead.
No,
Please,
I'm listening.
please.
I'm listening. I'm listening as well. That's a very realpolitik approach.
Yeah,
It's very interesting.
I said Al-Tabi, and I am aware about that.
Yeah.
Not Turkey. I am aware.
The question is, which is I think something I thought about when you were speaking. I'm not sure that what happened so far is what we're expecting to happen in the next 10 years. I think 10, 15 years ago, in the days that the constitutional and human rights age in Israel bloomed for at least some of the populations, not so much for the Arab population. I don't think we could have imagined the current climate. And I'm wondering, when we're looking, if it's not like, I don't know, it's a free translation. Can I say in English, like when you look under the
Okay.
under the projector?
Under the
If
lamp,
it's not, yeah.
in the lamplight.
If it's not like a very narrow and potentially dangerous perspective when we're looking on cases regarding land, when I think maybe more fundamental human rights and minority rights in Israel are now being jeopardized. And I'm all for realpolitik in many areas. But I'm wondering if it's not too narrow, perhaps. if we're not looking at government acts that would be much more severe and violate human rights and minority rights in ways that we can't even foresee now.
Yeah, it's possible, but the aspect of colonialism, it's not the land. There are three major issues in Israel that they appear.
Maybe I'll give just one
Yeah.
example.
In
What
land-
happened in Haifa last Friday.
Yeah, in land and citizenship and security, this is just one aspect. In citizenship also. But about the remark that the situation might be worse, and maybe we'll say, give me back Ka'dan,
Yeah.
and even give me back Dorner, Justice Dorner of Fikret al-Barak. Yes, it's possible. And maybe it's happening now. I agree with you. Like if I examine the response of the army about Gaza,
Response only of not only the army, but also the Khalakat al-Bagatzin, I
Yeah.
think.
Yeah.
it's totally different than all the historical response or legal opinion of the army. The historical legal opinion of the MAG, was that we applied the international humanitarian law, IHL. We made distinction between combatant, Rahamim, and civilians. We agree that we are not allowed to kill civilians, even if they belong to terrorist groups. The decision of the court in the assassination, sorry, they said even if you are terrorist, even if person terrorist, you are not allowed to kill. You are allowed to kill just if you have immediate information that this person now is going to threat our security in very serious way. Just
Ticking bomb.
Huh?
Ticking bomb.
Yeah. The state in the case of opening fires against the protesters in Gaza, they changed their paradigm. They said, well, we are allowed. The fact that they participate, the people, and big demonstration, and you are part of Hamon, big crowd, you risk yourself. That's mean that you might be killed even if you are not armed, even if you don't throw stones, even if you don't throw Molotov. So this is serious change. See, another serious change also in Milhiran. The Supreme Court has never confirmed displacement of any village, either West Bank or in the Green Line, but based on two reasons, security reasons or planning.
Yeah.
Here was clear racist reasons. Like they switch the security reasons with racist. This is a new, wasn't. In fact, all the time, the Supreme Court was concerned not to use cultural reasons. Even the family unification, they said we justify the law for security reasons, not for democracy. But here, the switch different. I think the family unification case, if it will come now, the Supreme Court, the majority of the court will say it justified not for security reasons, for demographic.
But wasn't that the case with part of the opinions in the last iteration, in the last version? I think it was.
They continue with their security.
I don't think the majority was on demography, but I think there was a plurality. That I think there was a number.
There were two justices, Jabareen and Prokacha, in the first round. They said we believe, but they were minority.
No, but in the second round, now I'm not sure I remember the
Gal'on.
What?
Saidin Gal'on.
yes, the details correctly, but who wrote the leading opinion was Gounis, if I'm right?
Gounis and Meltzer.
Yeah, and one of the people who joined Gounis joined them for demographic reasons, I believe. Anyways.
So you are right.
But that's part of the story, isn't it? Because you're saying there's going to be perhaps a shift and more international criticism if the Supreme Court won't see itself as
Yeah.
final. But maybe I don't know. I guess with the new nominations, we can now only dream of 5 versus 6 or 4 versus
Yeah, the
5.
Supreme
That's
Court
another
today,
thing
the
to take.
majority of the Supreme Court are white Yehudi.
Yeah, that's another thing to take
The
into
majority of the
consideration.
Supreme Court, even that they were nominated before Shaked, they were nominated 10 years ago. In the Palestinian cases, they behave like the like white Yehudi, like the justices who are nominated by the white Yehudi. Most of the Palestinian, يعني Vadot Kabbalah was rare, that 5 against 4.
Don't you think that's exactly where the split? I agree that the distinction between land cases is and other cases is significant and it's statistically proved, but I don't think there's a comparison to the Barak and Dorner liberal judgments on freedom of speech or freedom of adut,
Yeah, association.
association, or things that are now being very obviously jeopardized. And the current Supreme Court, I think it's an important distinction.
One of the strongest rights of Palestinians in Israel is the right of participation. Gronis court defended against disqualification of the Arab list, including Hanin Zabi. The court of Benish defended. The court of Lahore defended this right. And I think the court of Hayut will defend. This is the strongest right. Because this right, without the Arab participation, the Knesset will become Beit Knesset synagogue. So what make the Knesset doesn't look synagogue, Beit Knesset, because you have Arabs. So this is part of the identity of the state, to have Arabs in the Knesset. Israel is a democratic state because there are Arabs in the Knesset. This is even the model of Sam Smoh. Now, about freedom of expression of the individuals, I agree with you that we are witnessing to serious violence of the police brutality, and the Praklitut, or the Attorney General of the state, ready to file an indictment in the name of incitement against Arab individuals. And in Sukitan, many of the Arabs were kicked from many workplaces because what they wrote in the Facebook. And even in this university, some of them were threatened to be brought before disciplinary trial here. The problem with us, the Palestinians, that we used to. It's part of our history here because of the military regime. So this is also to come to convince it's not easy. But I still agree with you that the situation getting worse. Haifa police was the most tolerant police among all the stations in the country. In October 2000 was the most tolerant police station until lately, until just last week, we saw shift. Even they issue the route of the police, like statement that extreme right wing won't right. They said the police will express zero tolerance. This is the title. What's the meaning legally to express zero tolerance?
Break the law.
No, lobidity.
Break
The
legs.
lobidity. Libidity.
The
No,
law.
but historically
So
also,
break
this
the
is not
laws.
the first time the phrase is used. And when
Yeah.
they use historically this phrase is used, it means that we will not respect legal limitations on our actions.
Yeah, but I still agree with you that to take my publicly to take my opinion to support the SCAT and the overriding legislation, I have before I say I support it. That's all that. This is why I didn't write it because what you said in my mind. Well, like maybe the situation will be better. It will be worse.
It will be worse.
Yeah, will be worse. But for the Palestinian, the last station is for them the core. One of the things, the reasons why other minority groups in Israel, like Haredim or extreme right wing, they are against the court because they have power in the Knesset. The Arabs, they don't have power in the Knesset. So the only station became for them is the court that to have stage and
Thank you so much. This is not
Thank
a
you.
really happy note to end with, as we sometimes do in these academic discussions. Most of those that I've been part of did not end in a happy note lately. But thank you so much. It was very fascinating,
Thank you.
unsurprising.